Hi everyone, my name is Justine V. Hill, and today I'm going to be talking about drug testing in the workplace. So here are the few talking points I will be discussing today: the statistics, the history, the guidelines, the Drug-Free Workplace Act of 1988, the laws and regulations associated with drug testing, the pros and cons, and a case about a woman who refused to take a drug test. So I'm sure everybody knows what a drug test is. It's basically any test administered to detect the presence of drugs, which is taken by a blood or urine sample. So here are some statistics I have found. In a SHRM poll, 57% of employers conduct drug tests on all job candidates, while 29% do not. Drug tests are not common for existing employees. Nearly two-thirds of organizations, which make up 64%, do not conduct post-employment drug tests on existing employees. 67.9% of all adult illegal drug users are employed full or part-time, as most are binge and heavy alcohol users. Construction workers, sales personnel, food preparation, wait staff, and bartenders, handlers, helpers, laborers, and machine operators and inspectors reported the highest rate of current drug use, while protective service workers reported the lowest rate of drug use. And according to a national survey conducted by the Hazelden Foundation, more than 60% of adults know people who have gone to work under the influence or drugs or alcohol. And this is where ethics comes into play. A person going to work under the use of drugs or alcohol could be going against the code of conduct for that workplace. Why did drug testing become required? It became required because of the U.S. military. That's America's largest employer. So in 1980, 27% of personnel that were surveyed and admitted they had used an illicit drug a month before taking the survey. As a drug testing program within the military was started, during that 5-year period, 64% of the military personnel that were polled stated that they believed drug testing was the reason for the decrease in drug use. And 3 years later, drug use in the military dropped to 5.3%, and that's about 80% in about 8 years. So in 1986, President Ronald Reagan issued an executive order mandating a drug-free workplace with the intent that federal workforce would serve as a model for all American businesses. So the order required that all federal employees do not use illegal drugs on or off the job. It directed that the federal agency supervisors develop policies and procedures regarding the use of illicit drug use, implement employee assistance programs, conduct training for supervisors about drug use, and start a drug testing to identify employees who are in violation of the policy. So in 1987, the U.S. Congress passed legislation of the executive order under Section 503 of the law. So under Section 503, it established uniformity among federal agencies' drug testing plans. It ensured confidentiality for the drug test results. It centralized oversight of the government's drug testing program, in addition to providing funds to carry out these executive orders. So the reason for this testing plan was based upon recognition that marijuana and cocaine are the highest, most frequently abused drugs. So the guidelines under the executive order. So this requires urine tests in the following cases: when candidates apply for federal employment, after an accident or unsafe practice has occurred at the job, when there is an unreasonable suspicion that an employee uses drugs or is unfit for duty, as a follow-up to drug counseling or rehab program, and on a random basis among employees who are employed in positions that are deemed safety or security sensitive in nature. So the Drug-Free Workplace Act of 1988. It requires some federal contractors and all federal grantees to agree that they will provide drug-free workplace as a condition of receiving a contractor grant from the federal agency. This act does not apply to those that do not have, nor intend to apply for, contracts or grants from the federal government. The act also does not apply to subcontractors or subgrantees. Although all individuals with the federal contracts or grants are covered, requirements vary depending on whether the contractor or grantee is an individual or organization. So the laws and regulations associated with workplace drug testing. So under the Americans with Disabilities Act of 1990, So under ADA, employers cannot fire, refuse to hire, promote someone simply because he or she has a history of substance use or because they're enrolled in a drug or rehab program. Under the Civil Rights Act of 1964, employers should make sure that their programs treat all workers equally, and they should avoid singling out any employee with racial, ethnic, or gender group for drug testing. The Family Medical Leave Act of 1993. So under FMLA, eligible employees may leave work to deal with substance abuse disorders, treatment for drug and alcohol addiction, treatment for another physical illness or incapacity related to substance use, or caring for a close family member who is undergoing treatment for these conditions. Under the National Labor Relations Act of 1935. So under NRLA, any drug testing program affecting unionized workers must be negotiated and agreed with the union through a formal collective bargaining process. Even when an employer is required to implement a drug testing program by another federal mandate, the employer must negotiate with the union to determine exactly when testing will be conducted and what penalties should apply to workers who test positive for drug use. So what I found interesting is that New Mexico has no law addressing drug testing in private employment. So what this means is drug testing is not prohibited or restricted unless it violates another legal provision, such as prohibiting discrimination. So the ethical dilemma of drug testing. So what drugs do, drugs impair work performance and it lowers productivity. Drug and alcohol abuse costs employers about $100 billion in lost productivity each year. It is high absenteeism, high job turnover, higher cost of benefits for the employee and employer. There's higher accident rates, and when an employer is drug testing an employee, they're basically intruding on an employee's privacy. So employers have implemented a drug-free workplace program. They've seen improvements in employees' morale and productivity. They've seen better health status among employees. They've qualified for decreased costs in workers' comp and insurances. So at the end of the day, employers just want a fair day's work in exchange for a fair day's pay. So this is the case I found. It's Miss Barbara Luck versus the Southern Pacific Transportation Company. So Barbara Luck was a computer programmer for Southern Pacific Transportation Company, and she was fired from her job when she refused to take a random drug test. So what California has is a constitutional provision guaranteeing individuals the right to privacy. So what the argument held in court was the San Francisco Superior Court judge ruled that Southern Pacific basic drug testing program was constitutional because it served as a compelling interest in protecting the public safety. The question remaining for the jury was whether the employee performing duties like Mrs. Luck needed to be included in the drug testing in order to achieve the safe operation of the train system. So Mrs. Luck's duties included keeping records of supplies and budgets. She did not have to operate a train. So the jury found that the Southern Pacific had wrongfully discharged Barbara Luck, who had challenged the drug test on the basis of personal privacy. It also found that Southern Pacific was guilty of breaching its duty of good faith and fair dealing, of intentional infliction of emotional harm. So the case was introduced when Mrs. Luck, without prior notice, was asked to sign a form consenting to a drug test, and to provide a urine sample for testing. And she was the only one out of 500 employees who refused the drug test. So a week later, she was fired for doing that. So Southern Pacific subsequently halted its random drug testing program when San Francisco passed a city ordinance in November 1985 banning mandatory testing, except when an employer has reason to believe that an employee is impaired because of drug use. So if employers implement drug testing, they can avoid the issues that I've mentioned in the previous slides. I just mentioned that they make their company more productive and a safe environment. And some may argue that drug testing violates an employee's right to privacy. Some may believe that drug testing is not an effective way to screen employees whose on-the-job performance is being impaired by drugs. A drug that was used a day earlier or even a couple of days earlier will still register positive on the test. So the dilemma still stands. How do we respect an employer's right to a productive workplace while at the same time protect our fundamental right to privacy? Thank you, and I hope you enjoyed my topic on drug testing.